Hi everyone, my name is Daniel Wheeler and welcome to another episode of Gleaner Sports Live. Thank you so much for joining us. We close out the month of June in the courtroom, more so examining recent events that are affecting sports law. Not only just anti-doping, but also issues that affect sport legally. And who better to talk with us than Dr. Emir Crowne, noted sports lawyer. Say, Dr. Crowne.
Evening.
Evening, Dr. Crowne. How are you doing?
Good. How are you doing?
I am not doing too bad. Thank you so much for joining us.
Thanks for having me.
Thank you very much. Remember, guys, make sure that you have your questions for Dr. Crowne. Hopefully, we'll get a few of them before the hour is out. So thank you so much for joining us. The first thing I want to do is just get a little bit of an icebreaker thing to just smooth things smooth things easily, because not only that you frequent from Canada to the Caribbean, but you're a Caribbean man at heart. So I wanted to just put some things to you, some icebreaker, this or that section, to see exactly the first thing that comes to your mind, which one you prefer.
All right.
Okay.
Very nice.
All right. First thing, Destra Garcia or Nyla Blackman?
Sorry, Destra or Nyla?
Destra or Nyla.
Destra. That's easy.
Not even bad. Okay. Vacation or staycation?
Vacation.
And especially more important now that you're missing it because of COVID.
Well, actually, I'm actually in Ligani Club right now. I came into Jamaica today actually for a little vacation.
Excellent. How was the flight down?
It was good. Yeah. I mean, look, Jamaica's doing the best it can do, right? I mean, it needed to reopen its borders for tourism, so I mean, I completely understand. I had to download an app that tracks me, so Andrew Holness knows exactly where I am at all times. So my phone has an app that tracks where you go in Kingston, because you have to stick within certain areas and so on.
Mm-hmm. Well, definitely. Well, glad you're here. Glad you're here on the Rock.
Yeah. Happy to be here. In mango season is the best season.
Well, one more icebreaker. Richard Thompson or Asafa Paul?
Asafa. I have to go with Asafa. Yeah.
The originator. And also Camilla or Mia?
Camilla.
Yeah. And for those who don't know, that she was the former Prime Minister of Trinidad. For those who don't know. I wanted to, kick off this live just for, for those who, might be new to you, might not understand in terms of, the scope of what you do. We know that you're a sports lawyer, and we know that, you're prevalent in terms of, the different cases that you take on. But for those who are unfamiliar in terms of to your craft, what is it in terms of the broad stuff that you mostly focus on?
Well, I mean, I guess the field of sports law, you could say it's roughly 1/3 doping cases, 1/3 team selection, and then the final third is a mix of like disciplinary cases, those types of matters. But the bulk of the work, I think, is my work at least, is split between doping matters and team selection. Team selection matters are huge.
Because it's more, because mostly when people see you in the news, it's mostly for anti-doping. Is it I guess it's a field that you want to take on, or it was just by chance that you get normally of those cases?
Yeah. So the way I got into the field, 10 years ago, I was contacted by a wheelchair curler. So anyone who doesn't know what curling is, it's where you literally hurl a rock down a sheet of ice. And this wheelchair curler was banned for doping. And I'm like, what why would a wheelchair curler, you literally take your wheelchair and put it on the ice, and he literally sits there and curls the rock. And he was banned for having tamoxifen in his system, which is which masks the effects of steroids. So I'm like, this doesn't. I knew nothing about the water code, but I'm like, this doesn't make any sense. Why would a wheelchair curler need to dope to begin with? So I took his case on pro bono, and it was at the Court of Arbitration for Sport. Jim Armstrong against the World Curling Federation, and I mean I succeeded, but I succeeded purely out of interest. I couldn't. I still don't know how does a wheelchair curler get busted for doping. I mean, it boggles the mind. But that was sort of my start into it. And you know, once you do one case and you succeed, then through word of mouth, other people approach you and so on.
So that's basically more or less the origin story, as it were.
Yeah. That I mean, and this guy was in his 50s, in a wheelchair, paralyzed. And the story is, tamoxifen is used to treat breast cancer, and so his late wife, she had an old pill bottle of tamoxifen that is a round white tablet. It looks exactly like aspirin. So he takes aspirin every day, and it just so happened that one day he took his wife's tamoxifen. And then he got drug tested. And I always remember at the arbitration, he had on like a tight polo shirt, and he grabs his gut. He just takes his gut and he shakes it. And he says, "Do I look like I'm on effing steroids to you?" And then the whole panel sort of had a laugh. And I mean, it was completely unscripted, but I mean, it proved the point. I mean, this guy, you know, normally steroids, you could see some muscular development, but there was nothing of that. It was truly an inadvertent case of doping. So he was banned for 2 years, and we got it reduced to 6 months. And then by the time we had the hearing, his ban was up anyway. And then he captained Canada's team at the Sochi Olympics that won gold. So happy ending.
So pretty much. I was scrolling down in terms of, I guess, there was I think a presentation that you made, and you talked about mediation, and in terms of, I guess, how important you thought it was. But you said that you originally you didn't think so, you know, for a few years. What was in the nature of the work that you do? What was the case, or I guess the moment that basically shift your mindset, saying that, you know what, mediation is, you know, a very useful tool?
Well, I guess, I mean, if you think of lawyers as a whole, or the legal process, I mean, it's very sort of, you know, I plant my flag in the sand, you plant your flag, and then let a court decide, right? I mean, there's no middle ground. And that's how most lawyers view their practice, particularly West Indian lawyers. That's how litigation is viewed. But there are a few cases, but there was a particularly skilled mediator named David Bennett, I'll name him. And in Canada, as part of the dispute resolution process, there's a mandatory 3-hour mediation. It could go longer, it could be shorter, but it's normally mandatory 3 hours. Whether you like it or not, you have to do it. And David Bennett had and still does, has the unique ability to, what he does is he puts each party in a sort of separate teleconference or separate room, and he sort of beats you over the head, right? He kind of says, look, these are the weaknesses in your case, these are the weaknesses in your case, and then we all kind of come back together, and we slowly inch towards a middle ground. Like February, March, we had a 8-hour mediation. It was 3 hours, and 2. And it dealt with picking Canada's Olympic rowing team, back when we thought the Olympics was going to happen. And as you can tell just by the length of that mediation, obviously the federation thought there was no room to move, and then the athlete said there's no room to move. But 8 hours later, we came to a settlement. And it's remarkable because in sports, more than anything else, you need to maintain the relationship with your federation. And I think mediation is a big part of what's missing in the Caribbean in terms of Caribbean sports dispute resolution. Because you sort of go hard at your federation in some sort of arbitration or high court process, but it's not really conducive to the long-term interests of the sport for either party. If there's a way to mediate and have a settlement, then everyone wins. Because you need, whether it's a team sport or not, you need to maintain those ties with your federation. And likewise, the federation needs to come across as being athlete friendly. Like it can't come across as being nepotistic or whatever. So I'm a big fan now of mediation, particularly for sports.
So because of that, you feel that it saves a lot of headaches in the long run when you're in future dealings with federations.
Yeah, especially for team selection matters. It's very helpful. Doping matters. There's less scope for mediation, really. I haven't found the value in mediation for a doping dispute yet. Other people will tell you it's helpful to narrow the issues. If you can, if you start off here and then you narrow it down to a few issues, but I don't find that too helpful. I mean, in a doping dispute, the water code is already slanted against the athletes. Athletes have an uphill battle, and it's on whoever, JADCO or whoever, to prove their case. So I'm not going to narrow any issues. You prove your case.
Well, in terms of speaking that, I want to go in terms of the right into the anti-doping section of of what you do. And recently, in terms of you decided to take up the case regarding 400-meter world champion Sawa El Nasir. Now, I want to know in terms of what was it in terms of like the call that you got? What made the decision to decide to represent her in this particular case?
Well, and I mean, look, there's a statement out there that she made on her Instagram Live that missing these tests are normal, right? So, and that statement has been repeated widely in the press and so on, and I kind of wanted to know really what was meant by that, and I will reveal to you, like we've had that discussion, and what she was trying to convey, it didn't really come across that way, is that having a filing failure is not uncommon, right? So the water code, all local anti-doping rules in every jurisdiction, they allow 3 filing failures before it counts as an anti-doping rule violation. So there are many athletes who miss like 1 or 2 filing failures. And for the viewers who don't know, athletes need to enter in their daily whereabouts. So you need to say like between 6 and 7 a.m. I'll be home or I'll be in the gym or something, so that when the doping control officer wants to test you randomly, they know where to find you. So you need to enter that information every day. It's called your whereabouts information. And you're allowed to have 3 failures before it counts as a rule violation. So there are athletes in many jurisdictions, including Jamaica, who've had 1 or 2 violations, but you never hear about it because it's not a rule violation. So if you accumulate 3 in 12 months, then you get nailed with a violation. But if you miss 1 or 2 and 12 months passes, slate gets erased and you start over. So that's what she was trying to convey, that in that sense, it's not an uncommon thing. Like, you just don't hear about it because you don't get past the number 3.
Because in terms of, because obviously now, because of everything that's been hyping up in terms of doping and the perception, it feels it's a lot in terms of, I guess, negative towards her in terms of whether she was in terms of serious about the filing or whatever. And I guess a lot of questions have come to light. But in terms of your defense, what will be in terms of, I guess, the things that you would want to make sure that whenever the case is heard, will you be trying to convey to that board?
Yeah, that one I won't reveal yet. But I will say tomorrow morning actually is our preliminary hearing with the chair of the disciplinary panel. So the chair is based in London, England, and so tomorrow is our first. It's called a preliminary hearing. So it's just where we set out a timetable to exchange written arguments and then fix a date for the hearing and so on. But I don't want to reveal too much about the defense, but there is a defense. I've said it before, like I'm at a point in my career where I don't take on a case just to take on a case. I take on cases that I believe have merit. So from Brianna Williams, I mean, take your pick of whatever case I've done. I've taken it because there was merit in Riker Hilton, all of those cases. But we believe we have a defense to what is being alleged against her, and we'll see how it turns out. I don't mean to be mysterious.
Because and going back in terms of to our our Instagram comments, I guess some persons may interpret it as being a little bit disingenuous because not making your whereabouts known, because you've explained the process in terms of how to make sure that in terms of this time for an athlete to make your whereabouts
right.
To test you. Do you feel that it might have been a little bit disingenuous because it does now in the public eye give that perception of doubt in your in someone's ability to make sure that they're clean?
Right. Yeah, and I mean, look, and that's the world of doping, right? Like once the allegation is made, then it's sort of intended to cast that shadow on athletes, and I think quite unfairly, right? I mean, look, you take VCB, you take Asafa. I mean, they've all had doping allegations against them, but they were all inadvertent. But the way the water code is set up, it's set up to forever leave that black mark on your character, which I think is wrong. Right? Like I think that athletes, the water code, incrementally through the years, it's just become unwieldy in terms of its fairness to athletes. And you have individual athletes suffering, but then you have a country like Russia that systematically cut a hole in the wall, literally cut a hole in the wall to pass samples through, to clean the samples and have it returned during the Olympics. And they get what, a 4-year ban? Literally systematic doping of a country. And they get away with what everyone agrees is a slap on the wrist. But then an athlete who may, and I'm not saying this happened, but it's close, you may have missed a flight, your flight was delayed, your connection was delayed, and therefore your whereabouts, that counts as a violation because you said you were going to be at the hotel, but then your connection was delayed. So doping control officer shows up at your hotel, you're not there. It's a strike against you. But if your flight is delayed or your flight, your flight plans change, these things happen, right? But then you have an entire country like Russia systematically doping, literally removing the seals on unbreakable bottles. Like the people don't know, but the bottles that are used to collect samples, the cap is not designed to be removed. If it's removed, it is supposed to show evidence of removal. They found a way to remove the caps, empty out the dirty urine, I'll say, put in clean urine, reseal it, such that there was no visible tampering to the eye. And so only when a report was done, you can see, if you look at it microscopically, there are microscopic fractures. But this is the level of doping that Russia went through to cover up. And they get 4 years. They're back in the Olympics. I mean, that cannot be a fair system internationally for doping.
And
it cannot be.
And I just wanted to piggyback on it because one of the things that I was interested in terms of from your perspective is, well, the organization and the code itself, WADA, and a system that is designed to ensure that there is no anti-doping, in sports. Because you've said that it is flawed, but why specifically? What are the sort of areas do you feel that it's flawed and it's set up against the athletes?
Well, okay, so the water code operates on what's called a strict liability regime, which is just a stupid fancy legal word for as long as something is found in your system, you're presumed to be guilty, right? So, and I will use Brianna Williams because the water code, JADCO rules, there are two provisions. So one deals with contaminated products, and then another provision deals with, I would say, inadvertent doping. Like there's no way you could have known. But they're separate provisions. And the only way really in the code you can avail yourself of the inadvertent doping subsection is if somebody literally sabotaged your sample. Like they sabotaged your Gatorade. They put something in it. Like sabotage. And only if you prove that somehow, then your ban gets eliminated. But if it's a contaminated product, the water code says you have to at least receive a reprimand, right? Which is what happened with Brianna Williams. So it was a contaminated product, but the water code doesn't allow you to completely eliminate the ban. You still technically receive a sanction. So you can be taking, I've had clients take amino acids, take protein powder, whatever, and it's contaminated with 1/1,000,000th of a nanogram of steroids. The best you can hope for in that scenario is a reprimand. But a reprimand is still a violation, and it would still disqualify you from events and so on and so forth. So it's completely stacked against you. And you've had athletes, some athletes have eaten contaminated meat and so on, that have been contaminated with steroids and so on. The fact that you still receive a sanction despite doing whatever you could do, that is materially unfair. That's not fair to athletes.
And do you think?
And so, yeah, go on.
Yeah, no, I was saying that because there was it's not just about in terms of, I guess, contaminated substances, but also because this goes on the heels of it for American 100-meter world champion Christian Coleman having his grievances and about in probably the same case of missing a filings test, and also was not pleased in terms of with the AIU, which is the Athletics Integrity Unit, about in terms of failing to disclose the whereabouts. But from a legal perspective, in terms of, is that criticism valid?
Well, I think the criticism is valid in particular instances. So a lot of times, and I'm talking about now cases that haven't come publicly to light, but that I've been involved in. So I've been involved in cases where athletes, Jamaican athletes, have had one or two missed tests. So the doping control officer claims to have shown up, athlete wasn't available and says, okay, this is going to count as strike number 2 against you. But what the water code requires, it's actually an appendix to the code, it requires them to do more than say they showed up. So they have to at least try, they have to phone the athlete, they have to try to get in touch with the athlete. This particular case I'm thinking of, the athlete said he or she would be training at a stadium, but the stadium was completely locked. Like they would be in the gym at the stadium. Stadium was completely locked. Doping control officer says, oh, not available, missed test. Claims to have tried to call this athlete, but fortunately there's an incoming log of everyone's calls, and we had no evidence that this person tried to contact the athlete to find out where he or she was at the time. I mean, the stadium was locked, so he or she was at home. I mean, all you had to do was phone to find out. And so, like, if you don't interrogate it further, it looks like a missed test. It looks like an athlete is somehow avoiding the doping control officer, but stadiums are closed, gyms are closed, flights are delayed, people move addresses, etc. Like there are mitigating circumstances, and what people fail to realize is athletes like Coleman or like Nasser or other athletes, it's not like doping control officer shows up once a year and, oh, I missed the test. These athletes are routinely tested over and over and over. So it's not like one day you missed the test. I mean, so that's clearly evidence of them doping. No. Because if there was, you would think other tests would at least show some trace residue or some trace amounts of whatever, whatever is the banned substance. So I think the way it's set up to make it look as though, oh, you missed the test, you must be guilty. I mean, I'll take Riker Hilton as the example. Like Jadko had alleged, he evaded doping control. And so that on its face, it looked, well, why would you evade if you're not hiding something, right? That's just naturally the reaction people have. But then when we took it to a hearing, the panel, the test is comfortably satisfied. So the panel was not comfortably satisfied that Jadko had approached him and notified him that he was selected for testing. Like he claims he was there on the field, his ankle was injured, he was there the entire day, and nobody approached him. And Jadko says, no, we approached you, you evaded. So, and that's an example. And like Riker's case, like I reached out to Riker because it didn't seem as though, the press at the time made it seem as though he wasn't going to contest it. And I reached out to him, and he said, Doc, I'm retired, I'm retiring, I'm not going to, I'm not going to. I said, but hold on, Riker. You're telling me, it's fine you're retiring, that's fine, but you want your last act as an athlete to be known as somebody who evaded doping control and received a 2-year ban? Like, you can't go out like that, man. So I did his case pro bono, and we prevailed. I mean, so that's an example of a system that on its face, it makes it seem like the athlete is guilty, but when they get a fair and proper hearing, the truth comes out.
One of our persons on the chat wanted to ask a question to you. I hope I'm pronouncing this right. Tali Tuli wants to ask you: have athletes ever sued for defamation?
Yes. So not necessarily for defamation, but like contaminated products. So the manufacturers of those products have been sued for negligence in the U.S. And normally those cases get settled because every case I've done with a contaminated product, at least a dozen of them, the manufacturer will always get on the phone and say, our facilities are completely clean. We don't know how this happened. Not us. We didn't contaminate it. Maybe the athlete contaminated at home. I don't know, right? Because all of these manufacturers on their labels, they will say, NSF certified and, drug free, and they will have all of these quote unquote guarantees that their protein powders, amino acids, pre-workouts contain no banned substances. So they rely on that fact. So they have in fact been sued once the athlete prevails, at arbitration or something against WADA or whoever. They are then sued and then they settle because they don't want the risk of a hearing coming out that somehow testosterone trace amounts are in, lot number 12, which is like a ton of protein powder.
Okay. Well, there you go. And I just want to piggyback off because you basically said the concern that you have with WADA is basically it's guilty until proven innocent. Is it? I remember that we had a discussion in terms of criminalization of doping, and is this just wanted to get your thoughts? Why does the criminalization of doping is not effective in your mind in terms of the larger anti-doping?
Yeah, I mean that's a good question, and it always rears its head every couple of years. The first point is, it's exactly what I said about contaminated products. If we criminalized it, VCB, Asafa, Brianna, they would have all had to serve jail time for a contaminated product that they had no idea was contaminated. I mean, that's A. I mean, you'd literally be jailing world-class athletes for something that they had no control or knowledge over. And secondly, the standard of proof would be much higher. So doping cases are measured on the balance of probabilities. Is it more or less true? That's kind of the test. A criminal doping charge, you'd have to be beyond a reasonable doubt. So securing a conviction, quote unquote, would be much, much harder in that regime anyway. So you may well have an athlete you caught like on camera shooting steroids, and it will satisfy a balance of probabilities test, but it may not satisfy the criminal standard. So that is a concern as well about criminalizing doping. And again, and look at filing failures. So because I missed 3 filing failures, then 2 years in jail. I mean, think about how detrimental that would be to the career of an athlete. If VCB, ASAFA, any of them had to serve jail times for a contaminated product, the career will be over. And so that can't be a fair system. And it also, WADA is just a private entity that exists in Montreal, Canada. So it can't go around the world, criminalizing stuff. It has no powers of a state. It would effectively be acting as some kind of supranational state if it even started doing that. So it can't. WADA would be out of its mind to even think of it.
Because and speaking of WADA, there was I'm not sure if you're familiar with a document that just released from WADA, the WADA Athletes Anti-Doping Rights Act, which was supposed to take effect next year. What are because it explained in terms of, I guess, what the athletes have rights to, even because you have your reservations of exactly what in terms of WADA and their system. Is this what do you think in terms of this act does in terms of to state clear for the athletes in terms of their rights in terms of education, but also in terms of right to legal representation regarding these cases?
Right. Well, I mean, it's funny you say that because I think it has like 17 articles in it, something like that. And like articles 1 through 13 are supposed to be universal articles that apply in every country, right? So right to a fair hearing, impartial tribunal, right to have your B sample tested. And for people who don't know, when you submit to doping control, you basically take your sample and you put it into 2 separate vials. And one vial is the A vial, that's the one that gets tested. If this one is positive, then the athlete has the right to ask for the B sample to be tested to confirm it. Because quite frankly, sometimes the B sample comes up negative, nothing. And then there's no charge. But what's interesting about this sort of Athletes' Rights Act, as they're calling it, is there are 3 or 4 clauses that are added in the end that they say are not universal. And one of the clauses is athletes have a right to corruption-free NSOs. So think about that. So you propose a universal standard, but one of the optional standards is an athlete doesn't have a right to a corruption-free sport. It's Article 14 or something. It's ridiculous. And then the last article, which is also optional, is athletes' right to receive legal aid for cases. And anyone who knows my cases, I mean, most of them, fortunately, I can do pro bono, but athletes need representation desperately. Because what happens in these cases is athletes either try to do it on their own, or athletes try to get their coaches to represent them or something. Athletes and coaches have a pastor pupil type. It's a very like religious, austere relationship.
Sacred.
And I mean, there have been cases in Jamaica where I've seen a coach represent an athlete. I mean, I don't understand why they would refuse my help. I literally sat a row behind them and I said, I will argue this case for you for free. But the coach insisted on doing it, and the athlete lost, unfortunately. But the fact that in this Athletes Act, Rights Act, legal aid and right to corruption-free sport are optional articles, it's laughable. Because anyone who's gone against WADA knows that WADA has infinite resources to beat you down with. WADA will get the best lawyers. They will get Christiana Ayotte. And anyone who's seen any documentary on doping, Christiana Ayotte runs WADA's lab in Montreal. And she is undoubtedly the world's leading expert on doping. Like, she's, to her credit, she is phenomenal. But she will always get on the line and toe WADA's point of view. So even if you, for instance, argue that 0.0001 nanograms, which is like a billionth of a gram, that must be contamination, she will say, well, no, we don't know. Maybe the athlete took it 3 weeks ago and their liver has now metabolized it down to just a little bit left. So maybe they were intentional. I don't know. And so she will say that, and it's probably true. So then the athlete has to go and get their own expert at their own expense to counteract what Christiana Ayotte, the world's expert, says. And so in the absence of legal aid for that process, it's an uphill battle against a code that, again, is stacked against the athlete. So the process is stacked against the athlete, and the actual law is stacked against the athlete.
So in terms of the act, so you're saying that because you mentioned like the three other articles which are recommended for other associations to follow. So what exact do you believe that for the second one, for legal aid, are those rights that should be implemented in order to give the athletes a lot more protection, to at least give them in terms of some rights so that they don't have to go it alone, you know, when they face, you know, these kind of cases? And also there's another clause that they need to be a part of the actual legislation process in terms of you know, anti-doping legislation. How do you feel about, you know, that kind of clause?
Yeah, I mean, to deal with the legal aid point, the same way that WADA funds labs like Professor Ayotte's lab, WADA should also be mandated to set up a legal aid fund. And athletes apply to this fund for cases where they can't afford representation. It's a pretty simple fix if you want to fix it. But if you don't want to fix it, then you leave it just the way it is, and then and nail athletes time and time again. So I don't think we're serious enough about athletes' rights then, that legal aid, it's the last article in the thing, and it's an optional article. So I don't think we're serious enough about athletes' rights. And it shows who has the power in WADA. When it comes to the code revisions and so on, it is entirely driven by this quote-unquote war on doping. When, again, as we said, the true warriors in the war on doping, like Russia, get a slap on the wrist. So, again, anyone who doesn't know what happened at the Russian Olympics, there was supposed to be a secure room where Russia's samples were held, and there was a tiny hole, like a little mouse hole, like in Tom and Jerry, at the bottom of the floor, where samples were passed through. They were cleaned up, opened, cleaned up, and passed back through and returned. Like it was systematic state doping. And why is Russia even allowed to compete, period, after that type of thing was uncovered? And it was Professor Richard McLaren. So anyone's heard of the McLaren report? That's what the McLaren report. He's done 3 now, but that's the McLaren report.
Well, I just want to say, you know, big up to, I guess, a lot of fans that you have here on the chat. Here,
I'm not accustomed to that.
well, I guess one of the comments that we have here from Rainman47: athletes should be left to the mercy of their prosecutors if they can't afford legal representation. So that's something that some of their persons agreed with you. But just I guess to wrap up, I guess what will be what in terms of this act? You said it's not. I guess it does not go far enough to protect the athletes. What would be in terms of, I guess, to close off this section, what would be in terms of a great way for a fix to make it more equitable?
Yeah, I think the contaminated products section of the water code, that needs to be revised to give credence to the idea that contamination occurs. And like I dealt with a case in Trinidad, a volleyball player. We went to the Court of Arbitration for Sport. I would say his family was so poor they couldn't afford beef, so they ate horse meat, like racetrack horses that were killed after their lifespan as a racehorse, and those horses allegedly, we're pretty sure, were doped up with testosterone, all sorts of stuff that if you consume the meat from those horses, because of your economic situation, there would be trace amounts in your system. And my guy was an unemployed welder. He's a welder by trade, but he's unemployed from a fishing village in Trinidad. And they found like a cocktail of 7 steroids in his system. Do you know how expensive it would be if he was actually using steroids? That's like $1,000 a month to afford a dosing of 7. Either he's secretly doing that, or yeah, he ate contaminated horse meat because his family's source of protein was dead racetrack horses. And so it's materially unfair that a situation like that, he gets a 4-year ban for something like that, when again you have state-run doping schemes getting away. And so I think more emphasis has to be placed on the idea that contamination occurs in the real world. And athletes, like, it's not realistic to expect athletes to, before you eat lunch, to have your patty sent out to test if your patty is contaminated. Like, it's ridiculous. So the code needs to be revised to recognize that in a contaminated products case, there should be no sanction. Not you don't receive a reprimand, you receive no sanction at all, if the panel truly believes the product was contaminated. And I mean, the code assumes that athletes will have all of their supplements tested by an independent lab. And you know how expensive that process is? That may work if you're in Florida. But if you're from a small country, from a developing country, where is the independent lab that I'm going to send my creatine, my amino acids, my protein powder, my fish oil, my multivitamin? And who's paying for that? But that is what the cases say, that the athlete should have had the supplement tested and so on. Like it was said in Asafa's case, in VCB's case. But it's not a realistic standard for athletes from certain countries. And the code is geared towards athletes from developed countries, where I can ship it. I know the lab where I can send it in Canada. I know the 2 labs I can send in the US. But where's the lab in St. Lucia? Where's the lab in St. Kitts? I don't know.
And this is just piggyback off because one of our viewers, DDOR876, and he wants to know in terms of piggybacking on that, is the Court of Arbitration for Sports an adequate body to deal with Caribbean sports cases? And I know that you've had to to deal with that.
Absolutely not. So I will just so the Court of Arbitration for Sport is hailed as the gold standard for sports dispute resolution. I think if that's people's idea of gold, I mean, it's fool's gold. First of all, to just register your appeal costs 1,000 Swiss francs, which is 1,000 US. And to have the arbitration heard by just one panelist is between 8 to 10,000 Swiss francs. Doping cases, 90% of the time, are heard by a panel of 3. So a panel of 3, you triple that. It's at least 25,000 to 40,000 Swiss francs. You give me one athlete in the developing world that has 40,000 Swiss francs lying around to fund a doping appeal. I think CAS is wholly inadequate to deal with doping disputes from smaller countries. And people will say, well, yes, but CAS has legal aid and so on. CAS's legal aid, you only get it if you prove that by funding the CAS appeal, you essentially won't be able to eat or pay your rent. Like, so if you're a middle class athlete, you would not get it. But I can sit here right now and tell you I don't have 40,000 Swiss francs lying around. Like if I had to fund my own appeal. It's a terrible system in terms of the cost. And I have advocated that we should have a regional sports court. It should be a CARICOM-based court where athletes can approach, and so you can have like a local court like we have here in Jamaica, and then an appeal probably. But the final level, instead of going to CAS, it should be a regional CARICOM court. And quite frankly, regional integration has failed on every level, but if there's one thing in the Caribbean that unites us, I have to say it's sport. If there's one thing that has the potential to unite us, it's sports. Because I don't know anyone from any island that doesn't want to see another island succeed when it comes to sports.
Mm-hmm. Well, guys, just remember, we're closing down. Only 11 minutes to go. So if there's any questions that you want to get to Dr. Crowne, now is really the time. Tali Tuli asks, do you think COVID will change that? And I think that she is talking about, for example, the court of the CAS.
Yeah. So right now, the Court of Arbitration for Sport has what they call emergency guidelines. And so they have suspended all in-person hearings, I think till the end of July, sorry. So it used to be that CAS at least liked the arbitrators and the athlete to be face-to-face. I've had cases where the federation has joined by video conference, but CAS, the arbitrators and the athlete like to see each other. But now CAS has moved to have all video conference hearings, which is fine, but it doesn't reduce the arbitrators' fees per se. All it would eliminate is the travel fees that are built in. But the arbitrators would still charge for the time of the hearing, the time to prepare for the hearing, and then the time to write the decision. So if it might have been 40,000 in the past, it would still be like 30,000 US.
So in terms of even though that you're missing the in-person hearing, it's still not.
Exactly. And I will say in Canada has something called the SDRCC, the Sport Dispute Resolution Center of Canada. And those hearings for the athlete, they pay a $500 Canadian fee, but everything else after that is free. So there's no cost for the arbitration. There is a roster of pro bono lawyers, like I'm on that roster. And so that system, you can have your trial, and then they also have a doping appeal panel as well to deal with disputes. So you don't have to go to CAS. And aside from the 500 Canadian, it's free. So it's a phenomenal system. And again, 90% of our disputes are done through teleconference or video conference. If you really want an in-person hearing, they have facilities in Ottawa, Canada. You can go. But the vast majority, we do it by video. People are like in British Columbia, people in all sorts of time zones, and it works phenomenally. And disputes are heard in a timely manner, because one of the biggest problems with any in-person hearing is getting a day when everyone's free. But if you say, look, we can all join from home, let's start the hearing at 6 p.m. Most of my hearings start at 6 p.m. Eastern time, and we go till 9, 10 o'clock at night, and we're done.
In other words, video calling could be the future.
And it should be, yeah.
Great.
Yeah.
One of my colleagues, David Mitchell, wanted to ask, has the proposal for a regional sports court been advanced? And if so, what is CARICOM's position?
Yeah, I raised it in the Gleaner a few years ago. I did an Olympic um, appeal, and I proposed it then. I said there should be a regional sports court, and I raised it then because viewers might be interested to know that all Olympic disputes are heard by the Court of Arbitration for Sport. So it's in the Olympic Charter. And if the dispute arose, I think it's 21 days before the game started, you have a free right of appeal to the Court of Arbitration for Sport. So we were able to advance an appeal for free for a Jamaican discus thrower, but only in that context. Had it not been an Olympic dispute within that window, he would have had to pay to go to CAS. And then that's when I said, look, the real access to justice, that's a kind of buzzword people like to use, is if there were a regional sports court. And so athletes can have their grievances heard. And doping cases get all of the headlines, but the real cases are the team selection cases that go unheard. And sports is the one thing that should lend itself to easy team selection. Like the fastest person, you take the top 3 fastest people, you're done. Unfortunately, it doesn't work like that, right? Somebody's neighbor didn't say good morning and whatever. And so people get shafted, people lose positions. And of course, the federation will have a justification for it. They'll say they're not psychologically ready. They'll have all sorts of grounds. But team selection disputes in the region, in the Caribbean, is something that needs to be addressed. I don't think that it's addressed at all, quite frankly. And we need to have that discussion sooner than later, especially when it comes to an Olympic year or a pre-Olympic year, because this is when team selections matter in terms of athletes' career. This is what they've been working for, 12 hours a day.
And just to wind down finally, just for that particular question alone. So, do you think that CARICOM would be open to such a regional sports court?
Yeah, you know what? I think CARICOM would, because I don't see a difference of opinion then when it comes regionally, when it comes to the Caribbean's need to protect its athletes and advance its athletes' rights. And I don't think CARICOM as a body would oppose a system like that. And it's a fair system because it is a regional body and we've all sort of accepted that. And it does have the potential to breathe life back into CARICOM. And it would be an innovative system, and it would be one that at least it allows athletes to achieve some semblance of justice. Whether you win or not, but at least you're able to access it, as opposed to CAS, which to the ordinary athlete is out of reach.
So it's basically up to the governments in terms of for CARICOM to basically decide what they're going to do and make plans to do it because it will benefit them.
Yeah. I mean, if Mia Motley is listening, I mean, she can give me a call anytime. I'm more than happy to talk to her about how we set it up and so on. Yeah.
Well, I guess that we can only hope. Dr. Crowne, it's unfortunate we only have an hour, but thank you so much. Thank you so much for chatting with us, sharing your expertise and insights. And hopefully I'm sorry we couldn't get all your questions in, but for those, we hopefully will be able to at least talk soon.
Right. Thanks for having me.
Yeah.
Have a good night.
Thanks a lot. Thanks a lot, Dr. Crowne. Take care. Cheers.
Cheers. Bye now.
Thank you so much for joining us on behalf of myself and the production team. We'll see you next week. Cheers.